Let's understand and confront the spurious defenses raised in a traumatic brain injury lawsuit. An individual who sustained a traumatic brain injury, often called a TBI, may need legal representation because the trauma which caused the brain injury was the result of someone else's unreasonable conduct, which the law calls negligence. These cases are vigorously defended by insurance companies and the defense attorneys they hire. The defense often seeks to take advantage of misinformation and myths about this invisible injury to discredit you, your injury, and your case. To succeed, you and your attorneys must know the many ways the defense may seek to cast doubt upon your traumatic brain injury and be prepared to counter these spurious arguments. We've prepared a paper now on our website. The link is in the text accompanying this video, discussing the recurrent themes we have encountered that insurance companies use to undermine your traumatic brain injury case. Because understanding and being prepared to counter the myths of TBI is the key to success. The more I prepare and anticipate these spurious defenses, the better the result will be for my client. So let's review some of these myths. Misuse of the term mild brain injury. Concussions are frequently misnamed mild traumatic brain injuries. This classification is based upon the initial presentation of the injury when a patient is assessed in a hospital emergency department based upon the Glasgow Coma Scale. This classification was not meant to predict outcome. It was created to assess the need for immediate emergency care, not to predict the eventual consequences of a concussion. A concussion is a brain injury, and there is nothing mild about these consequences, which may affect every aspect of a person's life. Pointing to no loss of consciousness. The belief that there must be a loss of consciousness to be diagnosed with a concussion is a myth. All accepted medical definitions of a concussion, including those by the Centers for Disease Control, the American Academy of Neurology, the Congress of Rehabilitation Medicine, and the World Health Organization agree there is no need for any loss of consciousness for a physician to make a diagnosis of a concussion. There was no head contact. You do not need to strike your head to sustain a brain injury. Physical contact with an object or by an object is unnecessary to cause damage to the brain. The brain is the consistency of jello. It is suspended and floating on cerebrospinal fluid within the skull. When the brain moves within the rough and bony interior of the skull and strikes the interior of the skull, injury results. When the head experiences acceleration and deceleration forces, brain nerve cells are torn, stretched, sheared, causing injury. The radiology studies were negative. X-rays, CAT scans, and MRI studies often fail to detect injury to the brain because they are simply not sensitive enough to recognize the microscopic changes and damage to brain tissue. These tests may be good at detecting fractures to the skull and bleeding within the brain, but they are not sensitive enough to detect the microscopic damage to nerve cells within the brain. Absence of proof is not proof of absence. These tests cannot determine if the patient is alive or dead. They cannot detect microscopic injury to brain cells and cannot provide information on how the brain is functioning. A normal skull X-ray, a normal CT scan, or a normal MRI study does not rule out a brain injury. This is a well-accepted fact supported by all authoritative medical literature, which must be shown to a jury in any brain injury case. When the patient was initially examined, not all of his or her current symptoms and complaints were recorded. Many signs, symptoms, and complaints following a concussion or other types of brain injury may not become apparent for hours, days, or even weeks after the initial trauma. Chemical changes take place over time, causing further damage to nerve cells. Many of the common complaints following a concussion do not become apparent until an individual attempts to leave their home, resume their normal activities, or return to work. Research has shown that concussions and brain injury are frequently misdiagnosed in hospital emergency departments. The testimony of individuals who knew and observed the brain injury survivor both before and after the traumatic event are essential in overcoming this defense. Malingering. Defense counsel and their experts may attempt to portray the brain injury survivor as exaggerating or making up his or her complaints by relying on false and misleading testimony, commonly called effort testing. There are many reasons that an individual suffering from a brain injury can do poorly on these tests, including the effects of medication they are taking, pain they are experiencing, anxiety and depression. Reporting of scores is easily manipulated with arbitrary cutoffs, and the norms used to compare a brain-injured individual to the general population are problematic. Your attorney must have a thorough understanding of the limitations of these tests and vigorously object to the conclusions that defense counsel seeks a jury to conclude from the results. Again, the testimony of those who have worked with you, lived with you, or interacted with you both before and after your injury are essential to overcome the spurious defense. Not everyone has a good recovery following a brain injury. Every brain injury is unique to the individual who was injured. Unfortunately, a good recovery is not universal, and recent studies have documented over 56% of individuals suffer long-term consequences because of a concussion. A brain injury case requires an attorney to possess specialized knowledge, and he or she must be well versed in the medical literature in order to effectively counter the myths of brain injury that insurance companies, defense counsel, and their witnesses seek to perpetuate in court. Thanks for joining me this week, and I look forward to meeting with you again next week on a new edition of the Brain Injury Insider.